Ready, start. We may note that the shortfalls and lack of lucidity in the statute do not constitute casus omissus, that is, single inverted comma, a case of omission, single inverted comma, close. It is well settled that it is not permissible for the court to apply the doctrine of casus omissus where the language of a statute is clear and unambiguous, as the words used by the statute speak for themselves, and it is not the function of the court to add words or expressions merely to suit what the court thinks is the intent of the legislature. As pointed out by a constitution bench in Nathi Devi versus Radha Devi Gupta, while interpreting a statute, effort should be made to give effect to each and every word used by the legislature, and a construction which attributes redundancy to the legislature should not be accepted except for compelling reasons such as obvious drafting errors. However, in a situation where it is not an instance of casus omissus by the draftsman of the legislation and there are ample means to gather the clear intention of the lawmakers, the statutory provisions which are seemingly lacking in clarity but are actually not so can be synchronized so as to give effect to the legislation as intended without the court venturing into the realm of legislative drafting. Such an exercise would only require harmonious construction of the provisions so as to give full effect to the legislation. From the statutory scheme as set out supra, it is clear that Section 195A IPC was conceptualized as an offence distinct and different from those under Sections 193 IPC, 194 IPC, 195 IPC, and 196 IPC. Those offences require a complaint to be made only by those named in section 195 within bracket 1 within bracket b within bracket first CRPC, and they were all non-cognizable offences. However, an offence under section 195A IPC was a cognizable offence and pertained to inducing a person to give false evidence by intimidating him/her with threat of injury either to his/her person or reputation or property, or to the person or reputation of anyone in whom that person is interested. The threat to a witness may be given long before he comes to the court, though the giving of false evidence under such threat is in connection with a proceeding before that court. That is perhaps the reason why this offense was made cognizable, so that the threatened witness or other person may take immediate steps by either giving oral information of the commission of this cognizable offense to the concerned police officer under section 154 CRPC, or by making a complaint to a jurisdictional magistrate under section 195A CRPC, so as to set the process of criminal law in motion, requiring that person to go before the court concerned, that is, the court in which the proceeding is pending, in relation to which false evidence is to be given, and inform it about the threat received, thereby necessitating a complaint under section 195 within bracket 1 within bracket b within bracket first, along with an inquiry under section 340 CRPC, would only cripple and hamper the process.